torture, you probably have a defense. And the defenses that were developed were self-defense and defense of others and necessity. And then lastly, and even if you don't have a defense, the torture law doesn't apply if you act under color of presidential authority. And that will take us off into the constitutional law realm, because it's the theory that under Article 2, the president, in effect, has the authority to order his subordinates to do whatever is necessary to protect the country, and other barriers, even statutory law, fall to the wayside. I'll just say that ultimately, as an example of decision-making, this was highly concentrated, secretive, not really rigorous or analytical, and as I'm suggesting, I guess, in this summary, reaches a really, really bad result. I'll just refer to a recent book by Ben Wittes, who has a book on the long war, the war against terrorism, he describes the narrowing of the torture definition in John Yu's memo as basically being laughable, that it's just so out of the normal realm. So, thanks very much.
Thank you. Thanks to Liz and the others for organizing this event. I think it's really important to have a discussion about these kinds of issues. In the interest of full disclosure, I should let you know that prior to my assumption of my position teaching international law at Stanford Law School, I was a practicing executive branch lawyer. I was a career lawyer in the State Department for 11 years, and so I have some views on these issues that are informed not only by an academic perspective, but the perspective of what it's like to actually practice in government and to advise policymakers. Now, Liz asked, I think, the very important question, why should we as lawyers and law students be concerned about the torture memos? Now I'm going to say something that's unpopular, okay? One of the things that we need to understand as lawyers is the limits of what law can do for you. So in other words, just because we think something is a good idea doesn't mean that it's legally required. And just because we think something is a bad idea, even an abhorrent idea, doesn't mean it's legally prohibited. And so with that, I think it actually is important to look a little bit at the application of 18 U.S.C. 2340A, which is the statute that implements the Torture Convention. Now before that, let's review, if I missed the video, it was a tough drive up here from Palo Alto today in the rain. Let's review what the memos that were released in April of this year revealed about the kinds of enhanced interrogation techniques that were approved by the executive branch. Number one, dietary manipulation. Number two, interrogating detainees while they were nude. Number three, walling, which involved firmly pushing them against a wall, but usually with a false back, so there was some give. Facial and abdominal slaps, cramped confinement, physical stress positions designed to produce muscle fatigue, water dowsing, which meant pouring cold water on detainees with a hose, sleep deprivation for extended periods of time, up to 180 hours. In the case of one detainee, who you mentioned, Zubaida, who was afraid of insects, placing him in a cramped space with an insect. And of course, the most traumatic of all of the enhanced interrogation techniques was waterboarding, which has been described. Now, the first question is, did these techniques constitute torture? Right? Well, what is torture? The statute that implements the Torture Convention basically says, torture is, in relevant parts, an act committed by a person specifically intended to inflict severe physical or mental pain or suffering upon another person. Now, a severe mental pain or suffering in turn is defined as the prolonged mental harm caused by or resulting from the intentional infliction or threatened infliction of severe pain or physical suffering or the threat of imminent death. Now, the other provision I think that's at issue here is Article 16 of the Convention of Torture. That obligates all states to undertake to prevent in its territory acts of cruel, inhuman, or degrading treatment or punishment which do not amount to torture. But to be clear, unlike the obligation to prevent torture, there's no obligation under the Torture Convention to enact a statute making cruel, inhuman, and degrading treatment, or CID, criminal. Now, my own view is that of these enhanced interrogation techniques, only one, waterboarding, actually involves the intentional infliction of severe physical or mental pain or suffering, as that term was understood when the United States became a party to the Convention Against Torture. And I should note that even that is not entirely free from controversy, since waterboarding, I think, is generally not understood as involving severe pain, but rather severe suffering. To the extent it constitutes torture, again, under the severe mental pain or suffering test, there's a question about whether you have to produce prolonged mental harm as a result of the suffering. Nonetheless, so I think that it is not an obvious question, right? And so the first thing you need to do as lawyers is read the statute and read the words and apply the law, right? Again, just because this is abhorrent does not answer the question of whether it amounts to torture, right? There's a role for careful, parsimonious lawyering. Now, I believe the standard is met with respect to waterboarding of the enhanced interrogation techniques, and I think it's notable that not only Attorney General Holder, as we saw, but also President Obama have stated publicly that waterboarding does constitute torture. I believe that is the correct interpretation of the treaty, but it is not an unambiguous, or it is not the only conclusion that one could reach. Now, it also seems to me to be beyond gainsaying that most, if not all, of the enhanced interrogation techniques also amount to cruel, inhuman, and degrading treatment, and so the performance of those acts violated the U.S. obligation not to engage in those kinds of activities. I think it's instructive in this regard to look at the standards the U.S. has generally applied when U.S. soldiers conduct interrogations of detained enemy combatants. The Army Field Manual governing interrogation methods expressly prohibits a number of the techniques that were employed by the CIA, including forced nudity and waterboarding, and the Army Field Manual more generally prohibits all forms of physical pain without regard to whether they are severe as a means of interrogation. So that, I think, is a matter of clearly prudent policy, and I think it's instructive that shortly after assuming office, President Obama issued an executive order prohibiting the use of any interrogation technique that is not authorized by the Army Field Manual. Now, there's another element to this, I think, that as lawyers and law students we should be concerned about. Another issue apart from the question of criminal liability. Although there may be disagreement about whether those who provided legal guidance in the torture memos committed crimes, and we can talk about that in the discussion period if you like, there should be no doubt about this. In my view, they engaged in monumentally bad lawyering. As any first-rate law student knows, the law is rarely black or white, but rather is usually gray. As a result, the lawyer's job typically is not to simply inform her clients of whether their proposed actions are legal or not, but rather to advise them of the strengths and the weaknesses of the arguments for and against the legality of those actions. In a world of legal uncertainty, a good lawyer's job, above all, is to advise her clients of the legal risks and consequences of pursuing a particular course of action. Now, I think the lawyers at OLC who worked on these memos utterly failed on this score. The memos never identified the significant counter-arguments to the view that the CIA's proposed enhanced interrogation techniques might not constitute torture, and they ignored the legal and policy risks associated with determining that waterboarding was compatible with U.S. obligations not to engage in torture and other forms of cruel, inhuman, and degrading treatment. Government lawyers, I believe, should be particularly attuned to such risks. When government lawyers interpret the law, particularly an international law rule like the prohibition on torture, they fulfill a function that is different from that a private sector lawyer does. They're not merely indicating whether their clients will be sued or prosecuted under the law. In fact, they're helping to determine what the meaning, what the content of the law is. Now, under the circumstances, I believe it's not enough for government lawyers to opine merely on whether a CIA interrogator can evade criminal prosecution for torture for waterboarding a suspected terrorist. Nor is it enough to provide officials with a legal avenue to carry out the policies they wish to pursue, whatever those policies may be. Lawyers should instead insist that their clients consider the broader implications of their actions in a way that takes the long-term interests of their client, in this case of the United States government, into account. For instance, does the conclusion that waterboarding is not torture reflect a more general understanding of the law that the United States wishes to embrace? Do we wish to expose U.S. servicemen and others to the increase of comparable forms of mistreatment by foreign countries? Do we want to undermine our own ability to condemn human rights abuses committed by other governments against their own citizens? Do we risk engaging in conduct that will undermine the moral and political leadership of the United States around the world in a way that interferes with our broader foreign policy objectives? I think there's no question that this, in fact, was one of the results of the torture memo saga. Now, I think it's perhaps no coincidence that the lawyers who wrote the torture memos were political appointees. Unlike career government lawyers, whose culture emphasizes serving the interests of the United States.